in front of you. So welcome everyone. Thanks for joining us today. We are honored to have Dr. Marsha Goetting here with us today to do the webinar Financial and Legal. Whoops, can you go back one, Marsha? Sorry. Financial and legal tools for caregivers facing double estate legacy planning. Sorry about that. I didn't have that memorized, so thank you. But we are so honored to have you here to do this webinar for us. So I'm going to turn it over to you to introduce yourself. And like I said, everyone else, if you want to, any questions or comments you have today, please put them in the chat and we will be monitoring. So thank you, Marsha.
Okay, well, thank you a lot, Mary Jo. And I am delighted to be able to present to folks in Minnesota and other places about this concept that I have with double estate planning. And I've been an extension specialist in Montana for more years now than I really care to admit. And it's been great here. I hear you've had snow. We've had snow. I got up this morning and jogged and I go, I can't believe how much is on each side of the road in our block. So it's winter time. And winter time is a good time to start thinking about doing estate or legacy planning. And you might say, well, what does she mean when she says, well, estate and legacy? And I keep trying to convince my audiences that estate planning is more than figuring out what you want to do with your assets. What it's about is those memories, those special events in families. And well, I'll be talking more about that. So I want to join Mary Jo in thanking you for attending the webinar. Whoops, let's get back home here. Okay, now Sarah is the one that asked me to do this program. And she said that I am supposed to get the participants enthusiastic about doing some estate planning and get you kind of motivated to do that. And then, of course, I say, Sarah, how can I do this? You know, I'm talking about dying, preparing for dying. And how are people supposed to get excited about that? But I guess I sometimes do because I think, estate planning is the thing that gives you control over the property, your legacy, and all those things. And after you're gone, that's what you leave as your legacy. So to keep your interest this afternoon, I'm sure a lot of you have done webinars or attended webinars, and sometimes they can get really boring. Well, I've got some participant engagement tools for you today. And one you've already used and take advantage of is the chat room. That is a great place to let the speaker know, you know, your questions, your concerns, and we really make use of that chat room. So let us know. The other thing that I want to do is throughout the session is ask a few questions, and Zoom happens to call these polls. So I thought I would start out with just a practice question so that I can get an idea of the 60 plus of you that are here today. What is it that is your background, you know, and that'll even tell me a little bit about why you're here if I kind of have this label, so to speak, about who you are. And I can see that we are having a lot of family caregivers. And of course, this would be a session that would be of interest to you and why you need to do double estate planning. Some of you have been former caregivers. We've got, some of you are picking up on this, future caregivers. Aha. Well, I thank you very much for sharing. And we've got some educators as well. And it's great. I know now that I have mostly the family caregivers, so I'll direct most of my comments to you. Now I got to get my green arrow away. And the other thing that I'm going to do then is go ahead and look at wildflowers. And you may say that this sounds a little weird, but you know what? I've been using these wildflowers for my estate planning programs and my webinars, and I find it just makes it more interesting for you and more interest for me for presenting. That way I'm not just blah, 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 and then the next slide, blah, 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 or at least that's what I've designed to happen. Now, what can I do to help you? Oops. Okay, So the first two flowers that I have are the pink monkey flowers, and they remind me, don't monkey around, get on with it, Marsha. Provide some of this information for people that need to be double estate planning. Now, you may say, well, okay, exactly what do you mean by double? And what I think of is you caregivers out there, you are assisting your loved one who is experiencing memory loss. And I bet that you are in different stages. Some of you are in the early stages, and this is where the most that can happen. And then some of you that are in the late stages, then that person may not have capacity. But I would also encourage you that you need to plan for yourself and for your loved one in case you are the one that goes before the loved one does. Now, this is a steer's head. Now, I'm sure if you take a look at it, you can see the ears and the eyes. And yes, this is a really neat flower that you can find in Yellowstone National Park, typically in May. And what it tells me is I want to steer you towards just quickly some of Minnesota's facts about Alzheimer's. I also want to steer you to the variety of tools that are out there that can help you with estate planning. And I also just want to share a couple of examples of families who did not plan and what were the potential consequences. Now, I like this flower because it's called a self-heal. But realistically, we know right now there is no self-healing with Alzheimer's. Once that brain starts to deteriorate, we don't have the solution yet to what's going to help individuals. So when I looked at Minnesota stats, I was just amazed. And of course, you're a bigger state than we are in Montana anyway, but you've got over 99,000 individuals that have Alzheimer's, and that's expected to increase by over 21% in the next 5 years. And then you caregivers. Oh my goodness, not only are you the salt of the earth, just look at the caregiving hours and the unpaid dollars. Look at that. It is $3.358 billion that you are providing for those out there that need assistance with Alzheimer's. Now, I have a concern about your health. What percent of caregivers' health do you think has become worse due to their caregiving responsibilities with the person with Alzheimer's? Is it 25%, 35, 45, or 55%? Okay, we've got those answers coming in, and we've got a lot out there that are saying 55%. We've got a group that says 45 and also 35. So this is really great. I'm going to just credit you right now. You guys respond to polls better than my Montana audiences do. So yay for Minnesotans. Okay, so what we're seeing is the majority of you, 55%, are saying it's 55. Well, let's take a look here. What it is smaller than that. It's only 35% that have reported that their health has gotten worse because of their caregiving responsibilities. And of course, that sort of depends too on an age factor there. I mean, good gravy. If you're 85 years old and you're caring for someone, chances are you've got your own health issues, and perhaps some of those are getting worse as a result of your caregiving. I have a really good friend whose husband has Alzheimer's, and he's in the very late stages. And at this point, if he falls down, she can't get him up. He can't get himself up. And so she has to call for emergency to come and lift him. So my concern is looking at you and saying, golly, what if your caregiver health deteriorates so quickly? Now, I know this is not a good something you want to think about. But what if you die before the person with Alzheimer's? So that means you've got to care about yourself and take advantages of opportunities where other people want to help, and also some respite to just get away for a bit and do something for yourself. So I'm really pleased with you. You want to continue to take care of that individual, then you need to take care of yourself first. Now let's turn to some of these tools that might be helpful, where you could either use them yourself or also for the caregiver, or I mean the person that you're taking care of. Now let's look at POAs, okay? Who is going to have power of attorney in the financial area and also in the health area? A power of attorney, we really need both of those. And not only does the caregiver need one, but the loved one needs one if the person still has capacity to sign. So I want to clarify, these are claret cups. I want to clarify, first of all, the financial power of attorney. This is something that you could give to your spouse or an adult child or anybody that you trust to handle finances in case you're not there to do so. So you see, this applies to the caregiver, and it also applies to the loved one with memory loss. So I'm curious, have you granted someone a financial power of attorney? Have you granted someone a financial power? Okay, answers are coming in, and it appears the majority of you, like 61%, do not have a financial power of attorney. But on the good side, we have 39% that do. So let's look at the principal. This is the person that's granting the power. Okay, makes me think of my high school principal. And I know it's not even spelled the same, I don't think. Okay, now let's clarify who the agent is. That is the person to whom you are granting the power. Okay, and one of the purposes of having this financial power of attorney is to explain to the individual that you're giving this power to, and I hope you had a talk with them, what powers are you giving to them? And then what duties do you expect that person to perform? And there is a liability now in Minnesota as well as Montana that the agent has to sign an indication that they know what they're doing. In other words, they're saying, I'm not going to take advantage of this person's money and go off to Nevada and do gambling, for example. You know, you say you're going to use it for the principal. Now, it's important you go through all this decision-making process to decide who you want. And then here comes Marsha saying you need to have a successor. And we need to think about that because your person that you've appointed could pass away themselves. They could actually resign. They could become incapacitated. Maybe some others feel they're not really qualified to serve, or when it comes down to it, they say, oh, I didn't realize it was going to be this complicated, so I won't do it. Well, that's why you want to name a successor. And your successor then will have the same power that your original agent had. So that carries over. So I'm wanting you to think about having a financial power of attorney for yourself and also for your loved one. Now here we have an explorer's gentian. And I think this is a beautiful flower, and it's one that we see in our forests in the month of August. It's one of those late bloomers. Well, as I was getting ready for this program, I found that Minnesota has a statutory financial power of attorney that is available from the Attorney General's office. And right here, I have a very long address. And I don't expect you to try to write that down. No, don't waste your time doing that, because what I've prepared is one sheet for you that there will be an address in the chat room, and you will be able to download that sheet and then just click on each of these resources that I'm going to mention to you. So that'll make it a lot easier. But it is neat that your Attorney General has the form. But I found that other organizations do as well. Your Minnesota Law Help also has a copy of the form and also the directions for filling out the form. And statutory just means this is something that the legislature passed, and when they passed the law, they had a suggested form for that. Now you'll notice here that there's this little funny box, and many of you may know that that's called a QR. Well, my secretary wanted to put it on my PowerPoints because she said, Marsha, haven't you ever taken your cell phone and, take a picture of that, and then voila, you're off to the place that you want to be? And I had to confess, no. But she thought I should have it there for you if it's something that you wanted to do. But I also told her, look, I've got this sheet. They'll be able to do it that way. Now, how long does a power of attorney last? You've got this financial power, and I have many people think that it lasts after you die too. No, your power of attorney ceases at your death. So that means can't use it anymore. Now, maybe the person that you nominated or named, in your power of attorney is the same person that you're going to name as your power or your personal representative. A personal representative is someone that you nominate in your will to take care of the estate. Well, for many of you, that might be the same as the power of attorney agent. So it's just after you're gone, they have to use the PR responsibility rather than the power of attorney. So caregivers and those in the early stages of Alzheimer's can grant a power of attorney. And that's going to make it so much easier, because there will be the days you won't be able to pay bills, or maybe that gets to be so much of a hassle. So decide who you want to have that power, visit with the individual so that they know of these listing of duties that you want them to do, and then execute, which means you sign it, you have witnesses, etc. Now, this is a flower that we have in Montana, and it does have a couple of names. Some people call it a purple frilly something. I call it a chocolate lily. And the reason I wanted to use it is it's a representative of the lily family. So representative makes me think about, I've got this power of attorney. Now you're going to tell me that there's an agency out there that won't accept the power of attorney that I just gave to someone? Well, let's see. What do you think? What do you think of these organizations or agencies will not accept a power of attorney? Is it going to be your Montana Department of Human Services, Social Security, the Minnesota Department of Revenue, or the IRS? So what do you think about that?
Marsha, there is a question in the chat asking the difference between, what is the difference between a guardianship and power of attorney?
Okay, I'm going to get to that pretty soon. So if you'll just hold that thought, I'll share that with you, because we also want to know the difference with a conservator. So what's the difference between a guardian and conservator? Okay, I think most of you have had the opportunity to participate in the poll, and I'm going to try something different this time. I'm going to end the poll, and maybe it means you could see it. Share results. Okay, there's the results. Okay, can you folks see the results? How about that, Mary Jo? Can you see them?
Yes, I can see them.
Okay, so what we know is half of you were saying the IRS, and then we've got 32% that said the other. So what I'm going to do is give you the answer, and it's the Social Security Administration. I got to confess, I was really shocked. I thought once you had a power of attorney, man, that was the legal tool that you needed, and everybody had to accept it. But no, Social Security has, for their own reasons, that you must have a representative payee. And they're not the only ones. I found the veterans pension wants you to be a representative payee, as well as the railroad retirement. And the representative payee then is the one that receives the money and disperses the funds for the things for the person that they're caring for. Now, there is a legal requirement here that there's medical confirmation that the person is not able to take care of their bill paying and other financial affairs. So that has to be done. The other thing the Social Security requires is they've got forms where you report how you spent the benefit money. And they have 3 different forms for this. Okay. And they also very much encourage you, do not mix the beneficiaries' dollars with your own. It's just a nightmare to figure out for you. And of course, if you get somebody like one of the children saying, well, you're misusing mom's money, you want to be able to prove where the money went. So there is a wording that you can use for the account. You list the beneficiary's name and then your name and then a comma, representative payee, or you have your name, representative for payee, and list the beneficiary's name. So you can contact the appropriate agency for the particular forms and more information. And what I did in the guide that you will be receiving that you can download is Social Security does have a guide for representative payees. So if you're a person that doesn't have a computer, what you can do is call that number toll free. And Veterans Administration has their own. And similarly, you can also go ahead and make the phone call to get a free copy of their book. And then the Railroad Pension has a publication that's the RB-5, and it provides your duties as a representative payee for the railroad pension. And again, a toll-free number, as well as one that you can just click on and go right to that particular publication. So my tip from the Chocolate Lily is a representative payee status may be necessary depending on what kind of retirement your loved one is receiving. So my Explorer's Gentian is saying, okay, make sure you do that. But I also then want to explore your health directives, because Minnesota has also, like Montana and other states, a written document that informs your relatives, your friends, what kind of treatments you would like to have. And you call it in Minnesota a Minnesota Health Care Directive. We use the term in Montana healthcare power of attorney. So you could name an agent to decide for you about the decisions, or you can name that agent if you want to give somebody else just the power to be able to do that. So now I'm curious, do you have a Minnesota Health Care Directive? All right, looks like we're going to need to do some work on this one. If I end the poll and then I share the results, we can see that 70% of you do not have a healthcare directive. And I know that's not the most fun topic to think about. I can think about money quicker than health decisions. But believe me, Minnesota has been on top of this for years, and that has been really great. So I'm going to stop sharing here, close the poll. And what we're going to do is provide you with a resource. And I found that there is, your State Department of Health does have a Q&A about healthcare directives. And I thought it was excellent. So that's why I listed that as one of the places that you can go to and find out more about a healthcare directive, because it's something that you can do yourself. It's not like you're going to have to pay an attorney to do so. And of course, you could have an attorney do that as well. But this lets you sit down, think through some of the process. And as I mentioned, the University of Minnesota Extension years ago were out there doing work in this area. And they have now a health care directive planning toolkit. And it's an excellent, excellent resource to be able to see, oh, okay, this is what it's all about. And I can look at these examples and decide what I want done to me and or not done to me, as the case may be. So take advantage of that, click on it and check it out. They have some healthcare instructions, they have some worksheets, and all of this stuff applies to part 2. It actually fulfills part 2 of the Minnesota Healthcare Directive. Yay for extension there. Then the healthcare goals were really important to think about. How important is pain control to you? It'd be way up there for me. But how important is it the use of life-sustaining or prolonging treatment? Well, that's one of those things that kind of depends. And so there's examples there that will help you reach a decision. And then how important are finances in healthcare? And I think about myself, some personal, if I knew I was terminal, do I want to use up a lot of my family money? Wouldn't I rather they take a trip somewhere and remember me and appreciate my life? I don't know. You have to decide on what your own planning goals are. Then there's an opportunity to actually list some of those medical procedures, and this is where they're explained. It also tells about when circumstances when this type of treatment would be used, and then it gets at you and your feelings. How do you feel about some of these kinds of things? And some of it may have to do with what we have talked to others about, what we have seen our families do. I remember in Montana, one of our members of the POLST group, which is Providers Orders for Life-Sustaining Treatment, was really upset because she said her friend in Oregon had put a pulse, well, pulse weren't available then, but it was the rights of the terminally ill. And she went in and discovered that her dad was on the floor. They were giving him a recitation, and it had been marked, don't do that. He didn't want to continue to live in a hospital for the rest of his life. So, hey, these worksheets are really beneficial. So what you do is you make the directive legal by signing it. It needs to be notarized, but that can't be your agent or alternative agent, with your power of attorney. And then you need to have 2 witnesses. And only one of those can be a direct provider or an employee of a provider on the day that it was signed. So my tip from the Explorer's Gentian is decide what medical treatments that you want and you don't want. Visit with your healthcare directive agent and make sure that you execute, that's what they call it, a healthcare directive form. Now this is Richardson's geranium. You see a lot of those in Montana in forests, but I want to introduce the Richardson family. Now, in this case, Dad is the one with Alzheimer's. And unfortunately, Mother Richardson passed away. Now, we know Dad has Alzheimer's, and they have found that his memory loss has advanced, and he needs to have a guardian because he didn't have a power of attorney. So we look at this guardian, and what we need to take a look at is, who is that going to be? Is that going to be one of the children, one of the adult grandchildren? So the guardian takes care of the person. The conservator is the one that handles the money. Okay, so here's more about guardianships. The guardian really is the one that says, where this person is going to live. They make sure the residence is in good shape. They're the ones that give permission for medical treatment and maybe some education, counseling, etc. They're the ones that can make this release of information, and they make end-of-life decisions. So that is a lot of responsibility on a guardian, okay? But this is a court procedure. We just don't do it automatically. We've got to go to court. Now, guardianships want to maximize the independence for this individual and do it in the least restrictive manner. And they are called upon to report to the court about how the guardianship is going, at least annually. Now, conservatorship, this is the one that handles the finances of an individual. And the same thing, we have to have a court procedure to have somebody appointed as the conservator. So their duties are to gather and make sure the assets are okay. If some property has to be sold, then we need to get some appraisals. Want to make sure that life insurance, or I'm sorry, health, homeowners insurance is being covered for the house, and the conservator is the one then that receives the income to be able to spend that. So you see, if you have a financial power of attorney and a healthcare power, or the health directive, you're taking care of this in a sense while you're alive, instead of making your heirs go to court while after you've are in a situation there where, well, you can't make that decision anymore. So the duties of the conservator is to make sure that they get permission before they sell the property, and of course report on the status of the individual. So they can be the same person, or you can have one person as the guardian and the other person as the conservator. So in this case, what the court did was appoint the son as the conservator and the daughter as the guardian. And after mom died in this case, the Richardson kids realize, dad can no longer stay at home by himself. It's just not a good idea. So what they start doing is looking at local nursing homes. So the brother says, well, I prefer Pioneer Manor. And the sister says, I prefer Lazy Acres. Okay, well, we have a brother and sister that never got along when they were younger, and they're not getting along now. And so who is going to have their choice? And here's what the brother says. The reality is, dad can't afford Lazy Acres. We have to utilize Pioneer Manor. So they've got to put their heads together and get that accomplished. So I'm kind of curious about you. In your family situation, which would you rather be? A guardian or a conservator, or both, or neither?
Marsha, there are a couple more questions in the chat here.
Okay.
One of them says, why do you need a conservator if you have financial power of attorney?
You don't. If you've got financial power of attorney, you're taking care of that individual. But the conservator and the guardian then are appointed if we don't have those individuals. Now, we may have to have a guardianship anyway. And I think in reality, usually the spouse is the one that is taking care of that particular individual, but the procedure is there in case we have individuals coming in from the outside. And there's the concern that, well, it happened in North Carolina. What the kids wanted was to handle the money so that they could use it. We even have a case in Montana where kids came up from another state and they locked their aunt in the bedroom and got her to sign a power of attorney. And then they were having a heyday. They took her money. Now, luckily, our Adult Protective Services stepped into that situation, thanks to a very observant neighbor. Okay, so we've got, I'm going to end the poll and share results with you, because I see the people that said both are probably thinking how much easier it would be if you only had that one person. They can think of these decisions right together. And then, of course, we have those that say, boy, I hope I don't have to be neither. So it's just not something I want to do. So thank you for sharing that. So I think it's wise to have a discussion with family members if you do believe your loved one needs a guardian and conservator. And this might even have to come about because you've got 3 kids, okay? And perhaps neither mom or dad are capable of making decisions right now, but all 3 kids want to be the conservator and guardian. So that's why it would wind up in the court, for the court to make that decision so that mom and dad get the appropriate care. Now, I want to steer you towards consequences of people that maybe didn't do some of these double estate planning. And I'm going to use our Montana wildflowers. In this case, it happens to be bitterroot. And it makes me the bitterness that it makes me think of that, of bitterness that can result because the caregiver and the person with Alzheimer's didn't plan ahead. So we're going to look at mom and dad. They have kids, the kids get married, and oh, everybody's really happy. And it was a happy time for this family. But here's the situation today. We had a son that passed away as a result of an airplane crash. We had a daughter die as a result of a car crash, and then mom died. So in this situation, you can see that I say dad has Alzheimer's, but I have a red lightning bolt on the son. What I want to know is if mom dies, what fraction, if any, does Minnesota give to the surviving son? So you're going to have some choices here: 1/3, 1/7, 1/9. And we have nothing as a choice. Okay, it looks like we've got the majority of folks coming in with some answers. We have nothing running strong. We have a third coming around the bend. I guess I wouldn't make a horse race announcer, would I? Okay, let's see what we've got here. We're ending the poll, and I'm going to share the results with you. And you can see that we had 46% say a third, and we had 49% say nothing. Well, in this case, what we've got is, drum roll, please. Those of you that said 0 have it right. It's the son who is not going to receive anything because it all went to dad. So that's why in this case, we would have to decide what we're going to do with dad. Can he stay by himself? How about a nursing home or home care? And can he afford it? And then we have to have a guardianship and a conservatorship for dad. We have to think about who would initiate this. Would it be the son or one of the adult children? So we need the caregiver to plan ahead and avoid guardianship and conservatorship proceedings. But what if we have double deaths? Let's say we've got a situation where dad was riding with mom and mom had an accident. So both of them ended up dying. The question then is, I've got a little lightning rod there on one of the grandchildren. And so I want to know, if you were the Montana legislature, what fraction would you give that child? And I might as well give you the choices: 0, a third, a seventh, or a ninth. What fraction, if any, is Minnesota going to give that child? So I'm going to give you a little bit of time here to check your questions with responses. Okay. Going to share the results here. Okay, what we've got then is 59% of you, I'm going to say, are mean, because you're not going to give that grandchild anything. And we have 8% said a third, we had 11% said a seventh, and what we've got then is 22% that said a ninth. Well, guess what? The ninths have it. You're probably looking at that and say, what? Now, why? Wait a minute. 2 pink kids, grandkids, get 0. We've got a turquoise grandchild get a third. Why is that? Well, at the top of your screen, you can see right of representation. And that's the way property is divided if that phrase is used. So this is without a will. Now, some of you may have a will and you're thinking, well, I don't have to listen to this part because I have a will. I would encourage you to pull out that will and take a look. Does it have the phrase by right of representation? If so, it's going to divide the property the same. But let's look at what right of representation means. Now, when my attorney first told me about it, I couldn't get it, even though he was telling me yakety yak. And so I said, draw me a situation, and I think I could get it. So that's what I'd like to do for you. I've already got it drawn, but here's the deal. The child that receives a third represents her dad, so to speak. Okay, so dad is gone. It doesn't go to his wife. It's going on down to the grandchild because Minnesota recognizes bloodlines. Or if the child was adopted, it would be the same. And you see the pink children receive nothing because the son is still alive. So that third interest goes to the son. And then these 3 green grandchildren receive a third of a third since there's 3 of them. So that's the way right of representation works. And you can do that in your family to see what happens. So we've got our ninth and we've got a third. And you can imagine if you were those 2 pink grandchildren, you would be saying, well, didn't grandma and grandpa love me too? And you can tell them, well, that's the law, but that doesn't really help with a kid, you know. Now, just looking at another scenario, if your will says you want it to go equally to your surviving children, then we've got a totally different division. We've got son is going to receive half, and if the daughter was alive, she would receive the other half. So wording in a will and on any of those things you sign at your bank where you're doing a power of payable on death designation, look at the small print and see if it is divided by state law or it says right of representation. So caregiver needs to accept the responsibility for double estate planning and whether right of representation is desired. Now let's look at another example of a joint tenancy between parents and children. Because one of the things we do as we age, sometimes we say, hey, can I put your name on the account? And that's what my folks said to me. And I was, well, I guess, they just wanted somebody to be able to get in there if they passed away. Well, this is what Sarah's done. She's got an $80,000 checking account, and she has put Susan's name on the account. But Sarah wants to make sure that that is equally divided among her 3 children. So she writes a will, and she says, I leave it equally to my 3 children. Okay, so how is that? It's just the checking account in this case. It's a legacy of $80,000. How is that going to be divided? Is it going to be equally to the 3 daughters because Sarah wrote the will? Is it all to Susan because of that joint tenancy that's there? All to Minnesota because of the joint tenancy? Or all of the above answers are wrong and Marsha missed the boat? Some of you know this right away. So what I'm going to do is end the poll here. I'm going to share the results. You 71% got that one correct. Good for you guys. Because you see, those of you that said equally because of the will, not going to happen. A will cannot undo a contract. Okay.
Marsha, I just want to let you know that you have about 10 minutes left.
Okay, thank you. That's my clock is right on time then. Okay, so we know that Susan was going to get it because of the joint tenancy, and the other 2 don't receive anything. So you think Susan will share? And that's not a question, but usually I hear a groan in my public meetings because people say, oh, I doubt it. So joint tenancy with right of survivorship doesn't take priority, but there is a way that you can still accomplish what you want to accomplish. And you can have what is called an agency designation. You there in Minnesota have the same law that Montana does, and it allows you to check on your form that you want to have multiple party account without survivorship. And if you do that, then the will would control and all 3 daughters would split that 80,000. So ask your bank. This may have been passed after you already had your accounts there and you've always just kept it as a joint tenancy. But if you decide that you want to have one of your children on there, consider the thought of the Multiple Party Account Act, because that allows them to write checks until your death, but it doesn't allow them to go in there and withdraw the money just for their own benefit type of thing. Now, here we have white mule's ears. And have you heard this phrase? Mom or dad is just stubborn as a mule. Well, let's take a look at that and see if it's really, really true. Here's mom, and mom has 2 kids in the years 215, and she has all the property in her name. But the children are wanting her to do some estate planning. And mom says, there's no way I'm going to pay $5,000 to an attorney to leave it to you 2 when the state of Minnesota is going to do the same thing. Why should I? Well, what the kids are concerned about is mom has started to date again. You know, their dad had died 10 years ago, and they're worried that mom might marry the good looking hunk in Coon Rapids. Okay. And she did. Now, I don't know if he was the hunk, but anyway, or whatever. New husband. And what did she do? Put it in joint tenancy. The husband, though, now, after a period of time, has Alzheimer's. But mom is saying, don't worry. I've written a will, and after the joint tenancy was formed, so you're going to get the property. I accumulated it while your dad was alive. So we've got a poll question. Will mom's kids get her property since the will was written after the joint tenancy was formed? And you're going to be able to answer this one quickly, and all of you are going to get it right, right? Do we have this poll?
Marsha, this one might not have been added. Do
Oh,
you want me to
dear.
add it quick?
No, because they're going to get it right. We
Okay.
learned this before, right? You can't undo the contract with a will. So it was just repetition. We'll ignore that one. So the husband with Alzheimer's is a surviving joint tenant. Of course, he's going to receive everything. Now, this leaves her kids with 0. And that really was not what she had in mind. So what we need to do is, let's say the stepdad dies, then where does the property go? You know that one, I betcha. Do you have this one, Lauren?
Yes, I do.
Oh, good. Okay, my mistake on that other one. Okay, how is this going to be? Okay, I'm going to close this a little bit because I'm starting to run out of time. And so I'm going to share results here. And, you guys aren't agreeing on this one. Who is going to inherit that property? And I'm going to show you it's his kids. Her kids do not inherit at all. So I dare say that's not what she wanted to have happen. And what we need to do is definitely seek some legal advice, because she could put that property back in her name only, and she could leave it to her children. She could leave it in a trust for the husband that has Alzheimer's, and then upon his death, it goes to her 2 kids. So there's lots of things that could be done. And there's the National Institute on Aging that has some information. So I wanted to let you know of that resource. And my observation from the Lady Slipper is that time has slipped by. I want to wrap it up, and because I bet some of you are ready to slip away. I hope I steered you to Minnesota's facts and figures about Alzheimer's. I hope I steered you to some of the tools that you could use, wills, we've got power of attorney, healthcare power of attorney, and you saw some consequences by caregivers who didn't plan. And if you don't have a memory like this elephant's head, we do have the University of Minnesota Extension with their tool planning kit for you. That would be great. We also have another group there that I just found out about at the University of Minnesota. They have the Minnesota North Star Geriatrics Workforce Enhancement Program. And they have resources, they have lots of information that are available to you. And I like to think of all of these as putting your taxpayer dollars to work for you, because they are meeting the needs of Minnesotans there in your state. This one, I hope, is also on that worksheet where you can click and click and click. Don't forget too, they do have a webinar session that they're going to be having on February the 15th. They tell me it's going to be about 1 hour and 15 minutes. And it's just going to be an information webinar session. And it is Dementia Friends. So I've got the registration information for you there, and I encourage you to sign up. It just sounds like it's a great program, and I would attend if I wasn't on the road. So I want to thank you very much for attending this webinar. I know it has been recorded so that you guys can go back and review anything that caught your interest. There will also be the links, and they will be on the paper. And at this point, what we're going to do is stop the recording, and then I will be glad to stay on and answer any questions that you have